The political plot thickens, especially after the Senate upheld the impeachment of Rigathi Gachagua by the National Assembly. Now, where does this leave us? We could see very fast the legal team representing the Deputy President Rigathi Gachagua rushed to court, which did again give conservatory orders to stop any process of resuming the office of the already impeached deputy president. And we could see that already the president had already appointed Kindiki to resume that office. If you ask yourself, is that according to law or where's the rush? So Dunstan Omari is a lawyer, and he says that according to the IEBC Act, the Speaker of the National Assembly or the Speaker of the Senate, that is Moses Wetangula and Amason Kingi to be respectively, have no powers whatsoever under the Constitution to declare the vacancy of the office of the Deputy President. Therefore, should there be any swearing in, that will be against the Constitution.
Once there's a vacancy in the office of the Deputy President, the Constitution says that within 14 days, go on.
Once there's a vacancy, and that vacancy is not declared by the Speaker, it is declared by the IEBC commissioners.
What?
The vacancy of a Deputy President is not declared by the President nor the Speaker. It is the IEBC's mandate. Once it is declared, the President has 14 days to nominate a candidate.
Wait, let's pause there. So even in the event of death, it's the IEBC that will gazette the vacancy?
It is them who declare.
Why? Where does it say that?
I can't be carrying the Constitution here, but under the IBC Act, that is a preserve of the IBC under the IBC Act.
To declare vacancies in
To
all.
declare vacancy. The Speaker will gazette.
Writs.
Writs. They will gazette. The IBC will declare that this place is now vacant. The President, within 14 days, shall nominate a person. That person's name shall be moved to the Speaker of the National Assembly. Within 60 days, that name shall be discussed. And if approved by 2/3 majority,
It doesn't say that in the Katiba.
it might be my constitution I'm reading, but that is the law. It must be taken to Parliament. Parliament has set a precedent that any matter being discussed, public participation is required. Any matter being discussed. So which means we are going to go to public participation. And this time, the question that will be there during the argument, you heard my good lawyer, Ongoya, ask, is public participation restricted to a county? Deputy presidents are elected at the polling station. The presidential polling results end at the polling station. So people will be going to court saying public participation should be at the polling station. That is the whole issue. But the journey is long. Those who listened to Justice Mwita when he said that the 29 cases, we will wait because of the philosophy of Montesquieu of separation of powers, let Parliament do their job. Once they have done, we will be seized of this matter. So the question whether jurisdiction is at the Supreme Court has already been decided. Jurisdiction is at the High Court. After the High Court, this matter, the Court of Appeal is having jurisdiction as an appellate court against the High Court. The Supreme Court will have to sit on this matter. I don't know why people are forgetting. Uhuru and my good friend Baba Raila Odinga started the BBI. It lasted in court 4 years. Wambura's matter lasted in court for 3 years. Elections were done before that determination was done. Mwangaza, the governor of Meru right now, and I was here with you, I told people, Mwangaza will be kept in office until the Supreme Court decides otherwise. Mwangaza is still in office. So this is the trend. If you look at the jurisprudence for those lawyers who have been following on citizens, the Wajir matter, the governor of Wajir was evicted and swearing in was almost being done immediately.
Yeah.
The decision of the court was that reasonable time must be provided for an aggrieved party to go to court to seek redress. So the special meeting that is likely to be held on Friday is academic. And the good speaker, who is a senior lawyer, knows it very well, that any type of shenanigan to try to swear in somebody at night, the Kibaki style at night, that was 2007. Kenyans moved away from that.
That's done.
And it is now the 2010 constitution. Transparency, openness, where people are involved. Let us see this process, how it goes. It is very bad music for those ones who wish Gachagua is hounded out unconstitutionally. But they are charging him that he breached the constitution. So it is a double.
I have the letter that issued the conservatory orders, and here it reads: in the High Court of Kenya at Kirinyaga, court name Kerugoya Law Court, case number HCCHRPET/E0115/2024, citation Honorable David Munyi Mathenge and Peter Gichobi Kamoto and one other versus Senate and Speaker of the Senate and two others. Orders court document before Honorable Justice Mwongo Richard Mururu. It reads: this matter coming up on 18th day of October 2024 for directions on the notice of motion dated 18th day of October 2024 filed under certificate of urgency before Honorable Justice R. Mwogo. Agency is certified. It is hereby ordered: 1. That the applicants to serve the respondents with the application by close of business today, 18th 10th 2024, that is the month of 10th, that is October. That the respondents to file and serve the responses within 3 days from the date hereof. 3. That the matters raised in the petition being of great national importance and urgency, and in the court's considered view having raised extremely substantial issues of law, the matter is certified for a bench of High Court judges to be appointed by the Honorable Chief Justice. 4. That accordingly the file is to be placed before the Honorable Chief Justice for appointment of a bench. 5. That in light of the nature of the matters raised herein, as noted in Order 3 herein, conservatory orders are hereby issued against implementation of the resolution of the Senate in terms of prayer. C. Of the notice of motion preventing any person, including the second interested party, appointed by the President and approved by the National Assembly, from assuming the office of the Deputy President. 6. That the matter to be mentioned before the High Court bench on 24th October 2024. 7. That orders accordingly. The judiciary of Kenya, given under my hand and seal of the Honorable Court, or this 18th day of October 2024. Penal notice. Take notice that any disobedience or non-observance of the order of the court served herewith will result in penal consequences to you and any other persons disobeying and observing the same. Given under my hand and seal of this court on 2024, 10th month, 18th at 15:37 hours. Signed by Honorable Claire Wanyama, Deputy registrar. Now, the conservatory orders are very clear that no swearing in, no assumption of office should take place. And you would ask, what was the rush in actually impeaching the deputy president? You will also ask, did it meet the threshold of even appointment? Because according to Danson Omari, they should even undergo public participation. So therefore, does it mean there are matters that should only be taken to public participation selectively in observance to the others or against other issues? Because there is a 14-day window that the president has to notify of the person he's nominated. But you see, in this case, he's appointing, but he should nominate. Then the IBC is the one in task, according to the IEBC Act, is the one entitled with announcement of the vacancy of that office. So, where does this leave us? Could Gachagua be knowing something with this legal team? Is there a game that is being played in between? Could we see Gachagua resume office because the orders as it is? Still, Gachagua is the deputy president. So the political landscape is yet to unfold so massively before our eyes, and let us wait and see what happens. Now, for me, there are two things that I'm looking here if it goes either way. Should the case be listened to and Gachagua be reinstated back in office, fine. He will continue dispensing his activities as the deputy president of the National of Kenya. Should otherwise be achieved, like should the court not be able to reinstate him back to office, but then they will overturn the impeachment, which again gives Rigathi Gachagua life in politics. Remember, impeachment will bar him from vying from any public office. But should the courts write off the impeachment, then Rigathi Gachagua politically will have gained so much. And as part of advice, I would ask Rigathi Gachagua, if I was to be the legal team, after the High Court, in case the courts listen to him and instead of maybe even decide to reinstate him, he should resign. He should resign. That will give him more political powers. Then form his own political party. That's how these political games are played. And if he decides, he can take William Samoei Ruto because he knows so much. Actually, what Gachagua should do is join the movement to make sure that William Samoei Ruto goes down. That's just my analysis. If you love content of this nature and you're watching from our YouTube channel, kindly subscribe and press the notification button so anytime that we are live, you'll be the very first person to be notified. If you are watching from our Facebook page, kindly follow our Facebook page for regular updates. My name is Ahmed Halif for the Unscripted Talks here in Dab Radio. Assalamu alaikum warahmatullahi wabarakatuhu.
Kwa timba kali za Afrika, Dab Radio ndio mpango mzima.